Tinubu's hope of dismissing Peter Obi's drug trafficking allegation against him dashed. The Court of Appeal has dismissed the suit filed by APC and its presidential candidate Nola Tinubu against Peter Obi, seeking his disqualification from the February 2023 presidential elections. On Tuesday, the All Progressives Congress, APC, responded with objection to the petition filed by the Labour Party presidential candidate, Mr. Peter Obi, challenging the election victory of the president-elect, Bola Ahmed Tinubu. In its response, the APC called for Mr. Obi's disqualification as presidential candidate, saying that the latter was not legally a registered member of the Labour Party as at the time of the party's primary election. By the way, was Obi even a proper candidate? Was he a member of LP in the eyes of the Electoral Act 2022? That's the mountain we gave Obi and his team to climb. I doubt they will survive it. Part of APC's response to Mr. Obi's petition reads. The ruling party noted that Mr. Obi's petition against Tinubu is on shaky grounds and is thin in facts. Unfortunately for the APC, the appeal court had already ruled on Mr. Obi's eligibility to contest election under the Labour Party. The appeal court, which ruled in February, had dismissed a suit seeking Mr. Obi's disqualification. In the appeal marked CAABD CV 14142022, the Allied People's Movement, APM, had approached the court, contending that the Independent National Electoral Commission, INEC, should not have recognized Peter Obi as a valid candidate for the presidential poll. In a unanimous decision by a three-member panel of justices, the appellate court said there was no merit in the appeal filed by APM. APC's response to Peter Obi's petition challenging Tinubu's election victory, shared by Festus Keyamo, Tinubu's campaign spokesman, reads, APC has now responded with objection to petition and reply to petitions filed by AA, AP, APM, and LP. The frivolities put together as petitions have been laid bare. The other three petitions did not seek a return. Only LP did, albeit on shaky grounds. Aside from the fact that the LP petition is thin on facts, it is a carry-on of the propaganda that defined the Obi presidential ambition. All the blustering and posturing he maintained in his media outburst after the election results were announced are not repeated in his petition. You have to wonder why. He said he would demonstrate that he won the election, but same was stolen from him by INEC. Whereas in his petition, he admits that he could not have won unless the courts cancels the entire votes cast in all the polling units in 14 states and conducts a surgery on votes cast in 3 other states. That surgery will not yield enough votes to eliminate Atiku's lead over Obi, let alone scratch the gulf between him and Asiwaju. So it's a bridge to nowhere. What is more, he picked no issues with Atiku, who came second, and he failed to provide particulars of where he scored votes to challenge the margin of lead of both Atiku and the president-elect. In law, you can only prove by way of evidence what you plead. The LP petition, interestingly, took a detour into unrelated matters of the Chicago case, claiming this is a ground for disqualification. Well, again, this must have been introduced merely to excite their toxic fan base who need twisted versions of reality as oxygen. The case in Chicago was a civil matter brought under Title 281345 and 1355, which both relate to the civil jurisdiction of district courts in America in respect to civil cases brought by us government or its agency or its officers. Note: civil jurisdiction. Therefore, can a criminal conviction be made by a court in a matter where only its civil jurisdiction was invoked? It is like paying Jaguar for sedan and asking him to deliver an SUV to you. No, be which be that. To invoke the criminal jurisdiction of a court, there are procedures. To invoke its civil jurisdiction, there are separate procedures. But this is the circus LP has sent its supporters on. There are so many points on the watery nature of this ground, but let's just make it simple for all to follow. On the issue of FOCT, that is a matter of interpretation, and we are convinced that LP's proposition will work manifest absurdity and create preferred votes for FOCT residents, which has no basis in law and electoral jurisprudence. There is no example of such anywhere in the world where a section of the population of a country have golden votes to make or break a presidential candidate. so we are confident in our response to defeat LP's proposition. The other side to this issue is that LP benefits nothing from it should the court even most unlikely agree with them on this ground alone. It will rather spark a runoff between first and second and nothing more, because this is not a disqualifying element. Finally, LP says Shettima was not properly nominated. Section 31 of the Electoral Act 2022 settles that question. The vice president-elect withdrew from his senatorial nomination in compliance with this section, and that settled it. In all, LP threatened an earthquake, and we ended up with less than a slight land tremor or nothing at all. By the way, at least 2 of their lawyers are extremely known for their good work in election petitions. If LP had a better case, they would have presented it. They just don't have one. The fact that they are clutching at straws to make a coherent, credible case in court is the reason why we must ignore their empty grandstanding in the media space. It's all nothing but hot air.